Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing privacy in our text messages, the legal and ethical rules on the disclosure of private communications, and what to do if you believe that your privacy has been violated. Earlier this year, actor Jonah Hill's private text messages to his ex girlfriend were posted on social media. Hill has faced condemnation for the way he spoke to his girlfriend at the time, and others have raised concerns about his private messages being leaked by her after the end of their relationship. Now, we may each have a different opinion about the type of communication we would accept from a romantic partner. And even though we are all on the outside of that relationship looking in, whether we want to be or not, we all also may have opinions on Hill's style of communication. But there is an important legal and ethical question that comes out of this celebrity beef. What reasonable expectation of privacy do we have in text or other private communications, especially with current or former romantic partners? Here today to discuss this are two experts. Maura Grossman is a research professor at the University of Waterloo, and Irina Raisu is the director of internet ethics at Santa Clara University. Thank you both so much for joining me today. Now, don't worry, I'm not going to ask your opinion on the way Jonah Hill spoke to his ex girlfriend, unless you want to give it to me. But what I do want is your opinion on the legal and ethical questions about disclosing private messages. Maura, how does Canadian law treat text communication? What can you tell us about what scenarios might create legal recourse for posting private communication like this?
I'll start. Thank you for having me. I'll start with saying that I'm a U.S. lawyer, not a Canadian lawyer. But here's what I can tell you. I think in this particular area, the law may differ between the two countries, and here's why. There is a Canadian Supreme Court case from 2017 called R versus Marica, in which a person was convicted of trafficking in handguns, and he had texted with an accomplice, and there were no grounds for a warrant for his text messages or his phone, and but they had the phone of his accomplice, and he had texted his accomplice, and that was the information that was being used against him as pretty much the sole evidence of committing the crime. And surprisingly, the Supreme Court ruled, they set aside the conviction, ruling that he had a legitimate expectation of privacy in his text messages to his accomplice about this alleged crime, because firstly didn't come from his phone, they came from somebody else's phone, and they specifically mentioned that he had said to the other person, don't forget to delete these. And I think that would never happen in the US. I think that there is very little expectation of privacy, and probably even less when you're allegedly committing a crime. So Canada does seem to have a bit more protection. Now, this was in the criminal area specifically, but the court is very clear to say that expectation of privacy really depends on the facts and circumstances, and they look at whether what was the subject matter that you were texting about. Are you directly involved in that subject matter? Do you have a subjective expectation of privacy? And was your subjective expectation objectively reasonable? And I suspect who you are also makes a difference. I think when you are a celebrity or a public figure, the the scales are slightly, or the standard is slightly different. So let me stop there. But I do think in Canada there is somewhat more potential for protection.
And to clarify, that case dealt with a criminal law context where you have privacy rights that are protected under the charter. I think there, depending on the circumstances, there could be some scenarios where torts, personal injury suffered as a result of disclosure of private communications. In the right fact scenario, you could bring a claim for damages in tort. And there's also, of course, also the disclosure of intimate images. The non consensual disclosure is also covered by criminal law. We've got to go to commercial break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing privacy and text messaging, what to do if private text messages get disclosed to the public. Now, Maura, at the end of the break, we had been talking about some different types of disclosures, some types of recourse in the criminal context, as well as potential for tort claims if a partner instead of the government is the one disclosing your private communications. But there's the last scenario which I mentioned, which is texts that include intimate images, sexually explicit images. If someone sends a partner a sexual photo of themselves, when we're talking about reasonable expectation of privacy, do we need to say, this is for your eyes only, or is it implied that that is private? And what are the consequences for a person who discloses an image like that their partner sent them without their partner's consent, Maura?
So it's always good to make your intentions explicit. So it doesn't hurt to say these are for your eyes only. But when we're in the realm of intimate images, there are statutes and regulations and laws that prohibit this kind of what's often called revenge porn, things like that. So yes, both in the U.S. and in Canada, there can be repercussions for doing that with disclosing images without the other person's consent.
Irina, is there anything you want to add to that from a legal or ethical perspective about this issue of non consensual disclosure of intimate images? Which, to be
Yeah,
clear,
a
we
couple of
jumped off of this conversation about the Jonah Hill situation. There's no allegation at all that Jonah Hill did anything like that, just to clarify.
right. I think it's interesting that we are more concerned about the release of intimate images than the release of intimate details expressed in language. For many of us, I think words can be as revealing and make us feel as vulnerable as an image would. But societally, we just haven't thought about language that way. I would also say I would push back a little bit on the notion that in the US, we have less expectations of privacy. I think all of that is very much in flux. So, in terms of laws, I live in California, and Article 1, Section 1 of the California Constitution invokes the protection of privacy. So it's not that we haven't thought about it. How it gets expressed then in laws keeps changing, in part because people are understanding better what's happening with their information. I think online, the ecosystem has been so opaque that a lot of folks just don't have a sense of what might be happening with their communications. And if you think, for example, about writing text versus putting something down on a piece of paper, right? There's something about the act of writing it down on a piece of paper that I think, which, how many of us even do these days anymore, but it used to kind of make you aware of the fact that that piece of paper could be handed to somebody else, right? And there were certain things you might not have written down. I think texts feel very ephemeral. They feel more like a spoken conversation. And so people don't think about it with the same kind of caution that they would in terms of other kinds of writing. So our norms and our understanding and our laws are all developing to catch up with this.
Now, Maura, one thing that stood out to me from that comment is that we view our texts as ephemeral, and quite literally, you can turn on ephemeral texting. You can turn on self-deleting texting. If someone you're communicating with has that function turned on, their text delete every 24 hours or every 7 days, how does that impact our understanding of expectations of privacy? If, say, the other person in the conversation is screenshotting these texts that they know get automatically deleted.
Well, that's the key point. I may be deleting on my end, but that doesn't mean you're deleting on your end, and you very well can screenshot it or forward it or whatever. And therein lies some of the issue where the analysis is once it's sort of out of my control, once I've sent it and it goes to Arena, I don't have much control at that point over her phone and what she decides to do with it. And the law, it can be squishy in that area. So, for example, for certain social media, many courts have said, it's like
Right.
screaming out the window if you
Right.
put
Yeah.
social media.
We've got to go
So,
to commercial break now, but we will be right back. Welcome back to Canadian Justice, where we're discussing privacy and cell phone communication, text messaging, and what to do if your private text messages get leaked somehow, either deliberately by the other person in the conversation, or even perhaps through hacking or police access. Now, Irina, one of the questions I want to ask you, we used the Jonah Hill story as a jumping off point here, but I want to know how the ethics and damage of sharing private texts differ between a celebrity like Jonah Hill and someone else. Obviously, people are going to pay a lot more attention. Does that change the ethics around the decision to leak those conversations?
Well, it's interesting because arguably you could say that they suffer more harm because it's going to be publicized much further than if somebody had released the text of a regular person, and that their careers might be impacted. But I think I would argue sort of the opposite, that if we talk about privacy as a human right, then everybody has that right. And often when we talk about rights, we forget that they come with duties. We don't really have rights unless other people recognize that they have the duty to respect those rights. And that goes both ways. So I think the fact that you are, a public figure doesn't mean you completely lose your human right to privacy. And it's often, the old line about do unto others, or as you would have them do onto you, or don't do unto others what you would not like done to you. I think that applies to celebrities as well, especially if somebody is in a caring romantic relationship with a celebrity. I think that means you have further duties toward them as the partner in that relationship. And so again, if the harms can be greater, then the duty to protect your partner can be even greater as well. There's a type of ethics called care ethics, often also associated with feminist ethics, that says that you have, again, heightened duties to people you are in a close relationship with. And many of those relationships, parent child, or siblings or friendship, they can continue forever. But what happens when it's a romantic relationship that ends? Does that mean you've now stopped having that duty to care about that person? I think in something like the area of privacy, you don't. You've sort of taken on, you've sort of made a promise to respect this person, I think, even after you break up with them.
Now, Maura, I want to talk about how the expectations of privacy and perhaps the ethical obligations of privacy might change as the nature of a relationship changes. For example, if it begins as a friendship or even an employment relationship or a work relationship, and then evolves into a romantic relationship, does the expectation of privacy change then?
well, that's a really interesting question, especially when you start in the employment context, because often, certainly in the United States, I remember when I worked in the US and I would log on, and my computer very clearly told me that this was the property of the law firm I worked for, and that anything that used that system for, somebody else could look at. So I virtually had no private, expectation of privacy in my work email or online activities and so forth. But when you what happens when you start at work and then you move into the personal realm? I don't think you all of a sudden get these expect, your private rights back because it's now personal. So I think you have to be very careful.
Yeah, Irina, we have been talking about communicating using private devices. How does is the scenario different from an ethical perspective if the communication's actually taking place on a company cell phone, for example?
Um, yes, as far as the law is concerned. And I think yes, also in terms of the ethics of it, right? Because I'm hoping that by now people know that they need to switch out to some other device, and also that there are some really interesting ethical implications about that kind of changes in a relationship and the power dynamics at work. I mean, we could talk for a long time
That's a
just
whole
about
yeah,
this
that's a whole separate show.
scenario. Yeah. So I think that adds a whole layer of complication to what is already a complex question.
When we come back from the commercial break, I want to discuss how people can conduct themselves in a way that both allows them to have open and honest conversation with their partners, but at the same time can best protect their privacies. Maybe some practical tools. We will be right back. Welcome back to Canadian Justice, where we're discussing private text communication and what to do if it gets leaked. Now, Irina, we have been talking broadly about this issue about communicating online, but I do think that there is a balance. We want to be able to communicate openly with our friends, with our loved ones, and for many people, especially younger people, text is basically the same thing as conversation. It's how they communicate. And we don't want to behave as if, we can't trust our friends and loved ones, or if Big Brother is watching and that our communications could be leaked at any time and ruin our lives. But on the other hand, there is a possibility that they could. So how should people approach this dilemma? How should they structure their conduct with digital communications to get that balance right?
Well, it's interesting. I think some of the whole conversation around encryption is really about this, about finding some way for people to be able to communicate with each other without feeling like they might be, opening themselves up to public scrutiny. Um, and then you end up having to trust the companies that provide the encryption, and you still have to trust the person at the other end. Ultimately, it is about trust and respect, right? Anytime you communicate with another person, even if it's verbally, they could go and repeat your words to somebody else, right? There's something very different about, let's say, some girlfriends talking to each other about what the boyfriend said versus actually sort of looking at the communication, the written communication itself. And I think what to do about that is the reason, again, people are having this whole conversation about the release of the Jonah Hill's texts. I think that norm is shifting. And I think there is a growing expectation of privacy among everybody, including young people. And it's sort of fighting against this tension of having these tools that make it very easy to communicate without really thinking about the implications of what you're writing down. So there needs to be a much broader conversation and a lot more intimate conversations between people, because increasingly we don't want to assume that somebody else has the same privacy parameters that we do. They might have different things in their lives that really require them to be more protective of their writing than others might. So I think we really have to be sort of very open with each other about our expectations. And then accept the fact that we are still putting our trust in another person and in the ethics of their own behavior. And this is where I think virtue ethics would have something to say about all of this, because virtue ethics talks about the kind of person you want to be. So do you want to be the kind of person who's going to release other people's private information? Or do you want to be compassionate and kind and prudent and think about all the implications of your actions?
Maura, is there anything you want to add about how to get that balance right of being able to have an open conversation with your loved ones, but also protecting yourself from perhaps the threat that one day these communications could potentially be leaked?
Sure, I'll give a piece of advice that I don't follow personally, and that is to always assume everything you put in writing could be on the cover of the New York Times or the Toronto star. And if you don't want it there, then say it rather than putting it in writing. It's unfortunate, but that's the safest course.
Yeah, I mean, I think that that's not how a lot of people want to live their lives. Last thing, Maura, we've been talking about intentional disclosure by the other person in a conversation. How do things change if texts are hacked? We've only got about a minute.
There you're in a whole different realm because that's not something that I have voluntarily done. And I think uniformly courts and I think as an ethical matter that's viewed as a completely different situation, and there's much more protection in that context.
Especially, and I think that there can be a tort for privacy breaches in those cases, and I think there have been criminal penalties for people who were involved in big hacks, especially because the hacks have resulted in financial gain for some of the people who hacked prominent figures. Maura, Irina, that's all the time we have. Thank you both so much for coming on today to talk about this really fascinating legal and ethical question.
Thank you for having me.
We've heard today about concerns over privacy and text messaging and what happens if what you thought were private text messages get disclosed. How would you react if you were in this situation? And knowing the risks of disclosure, how might you change your behavior to better protect your privacy? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.